federal recognized that. Where are you?
Right.
He's the one who was yeah, I'm sure.
What's this bill number, Mr. Chairman? What's this bill number?
26.
I call House Bill 26 to be presented by Chairman Knox. Chairman Knox, would you present the bill to the committee, please? What happened to my quorum?
Thank you, Mr.
It's
Chairman.
here just a second. Hold it a minute. Yeah, there we are. Okay, good.
Thank you, Mr. Chairman. I'd like to say it's a pleasure to appear once again before this committee. I'd like to say that.
Weren't you here this morning?
Oh, first of all, could we exclude some of the witnesses? Mr. Chairman, this is a bill to prevent the use of the evidence of crime or an act that occurred prior or subsequent to the crimes alleged in an indictment, except under certain circumstances. One thing I think I have neglected in presenting this bill in the past has been that even in spite of this bill, if the committee decides to give this bill a due pass, is that even though it will restrict the use of extrinsic evidence of other transactions at the trial, except in the felony cases that are outlined in the bill, it doesn't prevent the use of those other transactions at the time of sentencing, so that any other violations that have occurred, whether there have been convictions or not, the judge can consider in imposing the sentence in any case. And I think that's important, and I think it's right that the judge should be able to do that in imposing a sentence, that he ought to be able to take into consideration any other convictions, particularly of a person accused of a crime who has been found guilty in the case at bar. This bill, as I've said before, it does track the federal rule that currently exists, and it attempts to codify, at least in part, the Superior Court rule with respect to the admission of evidence of similar transactions. And when I say it tracks it, I don't mean that it copies it. I mean it tracks it, or it mirrors, at least in a significant part, the federal rule and the Superior Court rules. The bill is limits the use of these evidence of other crimes, basically, except in felony cases and those that involve violent felonies. And those have been conveniently listed for you in the comparison of House Bill 26 and Federal Similar Transaction Rules that I believe you have in your folders. It's a 4-page document that was provided by the Solicitor General from the Forsyth County Circuit that happens to be in my district. And those felonies include murder or felony murder, armed robbery, kidnapping, rape, aggravated child molestation, aggravated sodomy, and aggravated sexual battery. And my hope and intent in this bill is to allow the courts to consider evidence of other crimes, whether the person has been convicted of those crimes or not, but to limit that use to the purposes for which this actually was originally developed under in Georgia, and that is where there's a question or issue in particular about identity. That is where you're dealing with a serial rapist, serial murderer, serial burglar, so on and so forth. And the purpose for that is, and the reasons why I think it should be limited to that is that there's a couple of good reasons. Number one is that if a person's committed a crime before, they've suffered their penalty, whatever it is, paid their debt, they've gone on. We shouldn't keep punishing them for that offense. Secondly, what we do want to do, however, though, is where there is a legitimate, genuine issue of identity. That is that we have a number of crimes that are unsolved, and the person that is before us has been arrested on a particular crime that resembles those other crimes, has the same type of entry to a building, the same kind of weapon used, those sort of things. And then we've had a string of those. And this is to get at those kind of offenses where we don't have an eyewitness, that nobody saw the person go in the building, nobody saw him shoot the guy, whatever it was. And so in order to be able to get at those kind of offenses, we want to be able to use those to identify this person who's before us in this court, to say, yeah, this is the same person that we're accusing in this crime, and by the way, we think he committed these other several offenses that are very similar in nature to this offense. And he may or may not have been convicted of some of those offenses. He may only have been arrested in some of those offenses. Some of those offenses that we're going to compare him to and say that they're for the purposes of identifying may have been after the case that we're actually have him before the bar to be tried. Now, I think it's, one of the things I think is interesting about this is that, you'll hear testimony, well, there's a lot of cases where you can't use this, that, you should be able to use it because this is a person who has a propensity to commit crimes. We ought to be able to show that they have the motive and intent. And really what's meant by that is that the person has a criminal character and they have the propensity to commit these crimes. That is to say that if they did it once before, they're likely to do it again. Now, that's like saying if I went to McDonald's and had a cheeseburger last Thursday, and I'm here this Thursday, the fact that I had one last Thursday should have proved to you that I was going to do it again. I had the motive and intent to go once again on another Thursday and have a cheeseburger. I'll submit to you that the intent and motive is not an issue there, and it's not an issue in the case at bar either. The state isn't, and the government is not required to prove motive or intent, either one. And intent can be inferred from the actions of the person. I don't have to have any specific indicia of evidence to show that they have the intent to commit the particular offense before them. As far as motive is concerned, when we're trying somebody for a crime, we don't really care why they did it. That's not really an issue. I don't care why they did it. I don't care why they shot some person or why they took somebody's property. I just care that they did it. And that's why they're going to go to prison if they did it. And they should go to prison if they did it. But I don't really care what their motive was. So motive isn't really an issue. So it seems pointless to be able to bring up other offenses that they may have committed or may not have committed, or that they may have been convicted of or may not have been convicted of, in order to show that they have motive and intent, neither of which are necessary for the prosecution of the case that's at bar. And finally, what I'm going to say is that there is no reason why, if you have a good case, you shouldn't be able to prove it on the merits of that case. You shouldn't have to go rely on other extrinsic cases that may or may not have anything to do with this case. You should be able to prove it on the merits of that case, because that's what the person's there for. If you can drag in anything you want to in order to prove somebody guilty of something that they're being tried for, then nobody's safe. And that's the purpose of this bill, is to present a bar to depriving persons of their constitutional right to their liberty and their freedom. There's an interesting case going on, and to give you an idea how far afield this can get, and I think this goes a good way afield, there's an interesting case where, and I won't go into the details of the crime or even the evidence in the case, but I'll just say to you that the core of the case, the core evidence of the case, that allowed extrinsic evidence to come in from another event. The person hadn't even been convicted of it, hadn't been convicted of the other crime. And the core of the evidence was forensic evidence. And the government was able to say to the jury, look, forensic evidence shows that this was the cause of death in this case over here, and forensic evidence shows that this is the cause of death in the case that we have before us. And then they put on their scientific expert, the forensic expert, and he said he'd only seen 2 cases of this in his whole entire career in 20 years. But the evidence came in about the fact that there was a similarity in another case, even though the forensic expert couldn't tell us about any other cases where this had ever occurred except in 2 cases in 20 years. That's a bit of a stretch, I think, to say that we should be able to prove that someone's guilty based on scientific evidence, when the admission of the expert witnesses, he'd never even seen this kind of evidence before except in 2 cases. So, and I don't think that's the only case. I think you'll see, for instance, in the Wayne Williams case where they had 27, I think there were 27 people that they claimed that they were able to bring evidence into the trial about who had been killed during this period of time during which they alleged that Wayne Williams was a serial murderer. And I don't make any comment about that case. I simply say to you that when you looked at those cases, there wasn't anything very similar in those cases. A lot of those cases, different ages, different statutes, different people, there wasn't anything very similar about any of them. Some of them dumped in water, some of them found here, there, wherever. Different manners of death and so on. But nonetheless, they were allowed to bring in all those cases. And I guess basically you could just put a dragnet in the ground and in the water and find anything you want and call that it was a murder that it belonged to that case. So I think it's a very dangerous precedent for us to continue on. And when I say that, I say it only because I think that we need to honor the Constitution, and that we ought to make it difficult to prove cases, and that we ought to only try the case that the person has been accused of, and we ought to only look at the evidence in that case, and we should make up our mind about the person's guilt or lack of guilt in the case based on the evidence in that case. And I think the only exception to that, and that's what this bill does, it provides an exception to that in order for us to be able to find those cases where there's an issue of identity, to be able to bring a prosecution in those cases where there's an issue of identity, where people have deliberately tried to conceal their identity or have it, and also to show that people have had a plan to commit these kinds of crimes, including the crime at bar. If they had a plan and a pattern of committing these crimes, then we ought to be able to introduce those. I think we still should should confine the use of those events to the most serious crimes, which I think are violent felonies. I'll stop there, Mr. Chairman. I'll take any questions or.
Thank you, Chairman Knox. Questions from the committee for the author?
To the author of the bill, I just want to ask some kind of simple questions to lay a framework in my mind, at least. What's the history of the treatment of similar transactions in Georgia, going back 50 years to the present?
Well, I'll say this. I'm not sure I can tell you the history of the treatment of similar transactions. I can tell you that it is a modern development in evidence, relatively modern development in evidence, in the use of evidence, and I think it's and there was a point in history where you couldn't, in our jurisprudence, where you couldn't bring this up at all. You couldn't bring up other convictions or other arrests when you were trying a person. You had to stick to the evidence and the facts that you could bring to bear in that case. And I'll admit to you, that was harder to prove a case then. But I don't think that's a bad thing. So I've probably told you about all I know about the history of similar transactions. Maybe the Lake Council can tell us more about it. Probably one of the witnesses will probably be able to tell you more about it.
The way they're smiling, I anticipate that's part of their discussion. Where does federal law rest on similar transactions?
We do have actually, my solicitor from my county was kind enough to prepare us a point-by-point comparison with respect to the federal rule and the House Bill 26. It also has some notes that she's been kind enough to provide us that explain the comparison. Yes, she is, and I'm pleased that she is too today.
Could you answer for me? I mean, I've not had a chance to read through her matrix, although I'm pleased to have it. Again, I'm just trying to put all this in a framework of, there's 49 other states, there's Georgia, there's the feds. I'm not sure that, we always compare ourselves against them, or
I don't.
But sometimes
for instance, I don't care what Massachusetts does. I really don't. I don't care what Alabama does either. I think Georgia has a good criminal scheme, with the exception perhaps of similar transactions, and with respect to the reduction of the unanimous verdict in the jury. I think we have a pretty good criminal body of criminal law in Georgia and precedent in Georgia.
Again, if I could, Mr. Chairman.
Yes.
You talk about again, we're talking about these serious violent felonies. For those less studied among us, if you could illuminate me here, what is the context in non-serious violent felonies or similar transactions? Does this bill do something to not allow them to be used there? What changes there, or does it not touch current law?
If you look, unfortunately for us, as I say, the solicitor was kind enough to prepare this summary for us on page 4.
Come up here and sit with you.
On page 4 at the bottom, it lists what the code lists as violent offenses.
I just thought you might want to summarize that for me while we're talking.
I can't. It's murder or felony murder, armed robbery, kidnapping, rape, aggravated child molestation, aggravated sodomy, and aggravated sexual battery. Those are violent felonies.
So similar transactions can be used in those cases currently,
Exactly.
but cannot be used in other cases.
Exactly.
So it's restricted to those. And this bill seeking to, for these cases, not allow them to be admissible, as they're not allowed in other cases. Is that the bill, or am I missing something?
I'm sorry. Ask me that again.
Sorry for not making it more clear. Similar transactions are only admissible in Georgia, as I understand, for those specific serious cases that are enumerated here on page 4.
Under this bill, currently you can use it for anything.
Okay.
Essentially, you can use it for a misdemeanor. You can use it to prove, bad habit of making U-turns. I guess you could show similar transactions on a U-turn case if you wanted to.
Okay. So the public policy discussion centers around, we think these cases are so serious that we wouldn't want any other information to be brought into the trial to prejudice a jury to bring a conviction using similar transaction evidence because the conviction and the penalties are so severe.
I guess I'm coming at it more from this standpoint. I think they ought to be used in these kind of cases. I think these cases deserve that kind of treatment, and they lend themselves to that kind of treatment because these are the kind of cases where you'll see that we need to be able to show that they have a pattern and practice of doing this. I don't think it's nearly as important to show a pattern and practice and as prejudicial to show it, I think, in misdemeanor cases, for instance, that somebody made a U-turn 4 years ago, and here they are again making a U-turn.
But this bill doesn't eliminate it for other circumstances, does it?
I'm sorry?
Does this bill eliminate the use of similar transactions for other cases?
It limits the use of similar transactions or extrinsic evidence, if you want to call it that.
Okay.
In other words, evidence that's not involved in this case. It's not doesn't have anything to do with any issue in this case. It's only what's contested in this case, but only when those cases involve these serious violent felonies.
Okay. I didn't read the bill to say only for these cases. There may be a word in here I just missed. Where is it in the bill that says only for these cases?
Yeah, let me see if I can read it for you. Let's see. As used in this code section, the term crime means an act committed in this state which constitutes a serious violent felony. That's on line 12. An act in violation of the laws of any other state of the United States, if committed in this state, would be a serious violent felony. That's on the first page of line 12 and 13. Yeah, I don't want you to be laboring on any misapprehension. Current law is now. It's not code. It's not. It's the Superior Court rule that allows this extrinsic evidence to come in. It's not
codified anywhere.
No. This codifies at least that portion of similar transactions that applies to these serious offenses. That's what this bill is doing. But it's only going to allow, as a matter of law then, that it'll be used in these serious violent felonies. And I think this is based primarily on the fact that you should only use this when you need to use it, and there's a question particularly of identity. Where you've got to be able to find the person who's been on a crime spree, and you need to be able to convict them of several offenses, some of which nobody saw him do. But we know that probably him because they all occurred in the same period of time, maybe the same county, they all involve burglary, maybe they're all arson, maybe they're all child molesting, whatever they are. They all have similar elements to them. In that case, I think it's appropriate and proper, particularly in violent felonies, to be able to use that evidence in order to show that pattern and that plan to do those things, and also to show the identity of the person.
Vice Chairman Moak, I think he might be of some assistance here. Michelle Hogan,
I think that what the thrust the author of this bill, what he's attempting to do is to say that there are a lot of crimes that are dragged in on similar transactions currently, and he's trying to restrict that somewhat. For instance, you might have a situation, for instance, in a gambling case where, for instance, you'd caught somebody at a poker game and you decided that you wanted to introduce evidence of them filling out a parlay card in some sort of a basketball lottery or something like that. That would be the kind of evidence in a similar transaction that you could introduce to prove that they had a propensity to gamble in a poker game. And it's that sort of evidence that I think he's trying to restrict.
I think
Only an XDA could have said it so well.
Can we see the brackets?
Today.
And Mr. Chairman, I asked the question because, I mean, I don't know where else crime's defined in the code. We've defined crime here. I would think that just the way this bill's constructed is somewhat, it's confusing to me, so I'm just trying to eat my money.
Representative Collins.
Thank you, Mr. Chairman. Mr. Chairman, we have concern about this. My question comes back to this rule. Then you mentioned Rule Superior Court Rule 31.3, which deals with similar transactions. Is it your opinion that this does not give adequate protection? Is that sort of I think was expressed very well by Representative Munford, but is that sort of your reasoning behind this bill?
Yes, but I want to explain what I mean by it doesn't give adequate protection. I don't think it gives any protection. I think what it does is take protection away. Remember, the issue in a trial is not whether, we heard yesterday awful testimony about, terrible things that happen. Terrible things that happen are not really what the trial is about. Do you understand that? Mm-hmm. The trial is really about whether the government can prove its case. That's why we say they're guilty or not guilty. We don't say somebody's innocent just because the jury said the government didn't prove their case, because that's what they're doing. They're not saying they're innocent, and that's not the point of the trial. The point of the trial is to require the government to comply with the Constitution so that the innocent are protected from the government. That's the primary function of a trial. It's the primary function of the Constitution. Constitution, I'm going to say this again, the Constitution is not designed to protect us from each other. It's not designed to help us catch bad guys. That's not the purpose of the Constitution. The purpose of the Constitution is to protect us from the only entity that exists in the world that can legally take your liberty and take your life and take your property. And that's the government. That's why we have a Constitution, because the framers of the Constitution had experience with that. They had what was called a king, and that's why we had the whole revolution.
Mr. Chairman, may I follow? And I appreciate again your sincerity and my question. Out of what you just said, being a constitutional issue here, then would you? And I'm taking what you just said. Would you then state that the Superior Court rule is unconstitutional?
I wouldn't say that. I think every case has a constitutional issue.
Right.
That doesn't mean that necessarily the rule is not constitutional. What I'm saying is that every case has a constitutional issue, and oftentimes we fly on laws we apply laws that are found to be unconstitutional in the Constitution itself. We had to go back and do some work. Some of the founders of the Constitution thought, for instance, that we should not count every human being in the United States as a full person. We ought to count some persons as 3/5 of a person.
And fortunately, that's been corrected. In House Bill 26, where you said it tracks the federal rules, and I would assume, as was so wonderfully put out here and helped, would you say yours goes beyond federal rules, however, in similar transactions?
In some aspects, yeah. I think so. I think some people would say the federal rule is not that good, and my attempt was to have one that that tracked both the federal and the Superior Court rules, so that we didn't leave. I don't want to throw out the baby with the bathwater, because I say we need a rule that allows us to use extrinsic evidence in very limited cases, in very limited offenses, particularly for the purpose of using it for the purposes of identity.
Okay.
And that's really what is at the basis of this, of even the rule there and the federal rule is both. The main use of it is to provide assistance in cases where there's a contest about identity or issues about identity that we can't otherwise resolve.
Okay. One last question, Mr. Chairman. In regard to that, and the question that came up earlier concerning what is, and I'll go along with the major crimes topic. This, however, would limit it in drug transactions, other issues of that regard, correct? Because that would not be one of these protected.
Unless the drug transactions involve violent felonies also, and oftentimes they do. But let me say this about drug transactions. We had 4 people killed in our county, not too long ago. So some people went in and shot 4 people in a house.
Yeah, I remember that.
It's supposed to be about drugs, okay? The usual understanding is that was a crime over drugs. And what I'm going to tell you is that's not a crime over drugs. That was a crime over money. Nobody gets killed over drugs. They get killed over money. And the reason they get killed over money is because the legislature, federal and state, all have seen, in their wisdom, seen fit to make it a crime to possess and use various kinds of drugs. And we did the same thing with alcohol. Didn't work. And this isn't either.
Yeah.
So I'll submit to you that I would not particularly cry over the fact that this couldn't be used for drug process or drug cases particularly, and for this reason, we can try and more drug cases than we've got the money or the time to try right now. We wouldn't need this rule, we wouldn't need my rule, we don't need any of those rules to do that. There's so much drug trafficking out there, so much drug capitalism going on that you just don't have a problem making arrests. They can make them all day long. Right now they have to go through and decide which cases they're not going to take, because they don't want to deal with little ones anymore. We're looking for bigger cases with more money, et cetera, et cetera. So, it wouldn't bother me if it wasn't used for drugs.
Well, I think over a good cup of coffee we could debate that one and probably find some common ground in that. I think this one was questioning, especially with the rules of us, that the judge at any time could say it's not going to be allowed. The state had to prove it to start with. That was where my concern was coming from.
Usually and these folks do a lot more of these than I do. But usually what happens is the judge gives limiting instructions about the use of that evidence. And the judge does that in other situations in trials where they give limiting instructions about how the jury should regard some particular evidence. The problem is that once you've told the jury that, the limiting instructions don't mean anything. Nobody pays any attention to those.
Okay. Thank you, Judge.
That's just one of those legal fictions, we try to pretend that means something that it doesn't.
I give you that. Mr. Chairman, thank you for your question. Thank you for your time.
Thank you. Representative Abrams.
Is there a concern about inconsistent application of the similar transaction rules as they currently stand?
Ask me some more.
Well, I'm just wondering, given that it's not codified, and given the difference in jurisdictions, has there been inconsistency in application of the Superior Court rules as they are currently treated?
I think so, and Representative Collins brought up the issue about drugs, and in some counties they don't bother with similar transactions so much. They don't need to. Because they don't have that, they got more cases to try than they can try, and so it's not that hard to get convictions. They're going to spend all their time getting convictions on cases whether they use similar transactions or don't use similar transactions, and that's always up to the district attorney and the judge whether or not there's going to be some similar transaction evidence allowed. First, the district attorney solicitor has to ask for the application of the similar transaction, and then the judge has got to decide whether or not it's going to be admitted. And it's not very often that they're going to do it, but yeah, I think there is inconsistency because sometimes they don't use it, other times they do. And, it's pretty arbitrary when they use it. I'd say, so at least to that extent, I'd say that's true.
So just as a clarifying, so this law would provide greater consistency in application across the state of Georgia.
Absolutely.
Thank you.
Representative Bearden and then Representative Benson.
Mr. Chairman, we're going to agree on a couple of things. The government has gotten way over oppressive. From everything from taxes to a lot of things that the government does, especially on the federal level. But if we want to protect all these innocent people, why should we even have these 7 circumstances? Take them all out.
Well, I want to. Here's why. I think that there are legitimate uses of evidence in order to particularly to establish identity. Back in when we first realized that there was such a thing as serial murderers, for instance, we had a difficult time getting convictions because you had to try each case at a time, and oftentimes once you got a conviction, you just gave up on the rest of them because it cost too much to try the rest of them. Whereas if you could bring in similar transaction, it makes them fall a lot easier. I mean, essentially, when you go to my experience, and it's just my experience, but it may be the experience of some other attorneys. But basically, when you introduce similar transactions, the jury stops listening.
Real quick, the Constitution.
That's all they need to know about the case that's before them.
If the Constitution is such a key element, and you feel it's bad for some, but not for others, I want to see a little bit of contradiction going on. And that's, I'm having trouble grasping your explanation on that.
Okay, tell me again what you think is the contradiction. I like to
Well,
be
you're saying
consistent above all.
it's okay for some, but it's not okay for the others. But and that's where I'm getting confused at. If it's a constitutional question to you, then it should just all be taken out.
Well, I don't think everything is the same. Just because I say that this should be applied to felony. For instance, we have 2 different classifications of crimes. We have misdemeanors and we have felonies. Some states don't consider traffic offenses to be a crime at all, but we do. If you make a U-turn in Georgia, you can be a criminal. You got a criminal record. Some states, it's just you pay a civil fine. End of story. There's no trial, no right to trial, no nothing. And those states that do that, that's up to them. It makes them, I don't agree with that, but some states do. And oftentimes things stay around a long time and are used a long time before they are declared unconstitutional. And a lot of people get screwed in the process. That doesn't make it okay. It doesn't mean we ought not try to address it.
Thank you, and thank you, Mr. Chairman, for bringing this bill. I know this question came up in subcommittee, and I'm trying to remember the answer. And it's been a while since I've tried a criminal case, but I have used similar transactions as a defense attorney against witnesses that the prosecution had called. Is it a Chandler motion? Is that what it's called? A Chandler hearing? I'm trying to remember. It's based on a case. So my question is, how does this affect the Chandler hearings? If you're a defense attorney trying to question witnesses about, I believe they call it prior bad acts or prior acts, not similar transactions in the Chandler hearings. But how does this affect those Chandler hearings?
Probably one of these witnesses can tell you better than that. My understanding is, if I remember correctly, is I think you're talking about under certain circumstances you could bring evidence of prior bad acts. I think. But I'm not sure exactly what the rule on that is, and I think you're talking about that's what you're talking about.
Yeah, actually, the first case I tried, I remember the witness, actually it was the victim, had a case, had several prior bad acts of getting into fights. It was a fight case, and I was trying to say that my guy acted in self-defense, so I was able to bring in some of those prior bad acts.
I think it's different for witness though than the accused. That's a distinct. I think
House Bill 26 would not prevent, defense attorneys could still try to bring out prior bad acts against witnesses.
With or without this, you can still impeach a witness.
Representative Levitas.
Hey, Mr. Chairman, I appreciate you bringing the bill as well, and I can hardly. I still want her to be up here with you because I want to see more about. I didn't know y'all were working together on the bill, but I'm glad because if she likes it, I like it.
thought you were back there with Gary Moss working with him on that.
If you had a choice, no offense, counselor, but what would you do? As long as we're going to treat the defendant differently, in other words, we would allow the Chandler motion but exclude the prosecution from using it, so it'd be a one-way train. Would you also be willing as a friendly amendment to accept a change to the pattern jury instructions that say you treat a defendant like any other witness, since we would actually be treating him very differently? In other words, any other witness would be subject to a Chandler type motion, but the prosecuting witness wouldn't.
I guess I'd respond to that by saying if you think if that's something good to do, I'd encourage you to get the legislative council to draft a bill to that effect and bring it before us. And I'll be glad to help you. If it's something that's good and it's fair and it's balanced, it's objective, it's constitutional, I'm going to help.
Well, that would be perfectly germane to this bill, isn't this? Okay. Thank you, Mr. Chairman.
Representative Benfield?
But jury charges aren't in the code.
I'm sorry?
Jury charges aren't in the code. We can't change that legislatively.
I can't change Representative a little bit either. He's going to do whatever he wants to do.
Well, these aren't code either.
We're not going to do that. I'm not going to do that.
Any further questions for the author? Any further questions for the author? If not, I think we had one or two people that had signed up. Ms. Abernathy, did you sign up to speak for the bill? I mean, to help your constituent here?
I'm from the government, and I'm here to help.
In his
That's all I
hour
can
of
say.
need?
I am Leslie Abernathy. I'm the solicitor from Forsyth County, and I am here today as unpaid legislative aid to Representative Knox.
Not nearly as unpaid as you're going to be.
I haven't even got
sounds like a
lunch
threat.
3 weeks of coming down here. But actually, all kidding aside, this is a very serious bill, and I'm here on behalf of the District Attorneys Association of Georgia and the Solicitors General Association of Georgia. As to, well, he's gone now, but Representative Setzler asked about the history of similar transactions in Georgia, and he was right by the looks that we were exchanging to know a little bit more about the history, and Representative Knox wanted me to be prepared to answer those questions. So I am. Similar transactions in Georgia actually date back to the first reference in Georgia law in 1851, prior to the code being written in Georgia. The uniform rule, which actually prescribes the procedure for the notice, the opportunity for a hearing, the ruling, and the admission, is in the uniform code. In the uniform rules, it is 31.3, and it is not in Georgia code anywhere. So this change would not be a change to existing law or code that mandates the requirements. It would be a change that affects the uniform rules. The Constitution. The Constitution of the United States starts with a preamble, and it says, "We the people, in order to form a more perfect union, establish justice, and secure domestic tranquility." That's the beginning of it. Okay? The first priority in the preamble is establish justice. The question is, what is justice in Georgia? Is justice in Georgia prohibiting prosecutors from using evidence of similar transactions in all misdemeanor cases? All misdemeanors. That includes DUI. That includes domestic violence. That includes potentially vehicular homicide cases, where someone is such a reckless driver, they've actually driven too fast for conditions before and killed someone, and yes, that's a misdemeanor, and they do it again. Do we want to exclude that evidence? Is that justice? This bill would prohibit the evidence of similar transactions in all child pornography cases. All, including those on the internet. It would prohibit similar transactions in the internet child molester predator cases, where people are online on MySpace talking to 14-year-old girls and pretending they are 14-year-old boys, and they are trying to figure out where they live and how they can come into contact with them. It would prohibit those similar transactions. It would prohibit, as was discussed earlier, the similars in every drug sale, trafficking, manufacturing case, including the sale of drugs on public school property or on school property. And I said this before, I'll say it again, as a mother of 5 children in our public school system in Georgia, I have a problem with that as a mom. I think that evidence should be able to come in. It would prohibit, despite what my good friend said earlier, it would prohibit similar transactions in arson cases. That's not one of the 7 deadly sins, so it would not come in. It would also prohibit it in child molestation cases. You would not be able to use that evidence. It would have to be aggravated child molestation before a similar would come in. It would prohibit that evidence in burglary cases, carjacking cases, fraud cases, concealed weapons charges, vehicular homicide felony cases. You drink and drive and you kill somebody and you run over them and you do that again and you hit someone when you're drinking or you're impaired. And that evidence would not come in as a prior similar transaction. The biggest losers in this, if this bill goes through, the people who will not get justice, are the 3 sets of crime victims we need to protect the most. Victims of domestic violence who can't or won't stand up for themselves. A battered person has been conditioned not to stand up for themselves. They've been conditioned to believe that what happens to them is what they deserve, it is their fault, and they have no rights. So when the victim comes into court and claims the spousal privilege and does not want to testify, the prior acts against that person can't be admitted. And those can be crucial in standing up for that victim. And yes, sometimes men are victims, but in my experience, every person who's ever claimed the spousal privilege in my court's been a woman. Who's been a woman who's been in a long-term abusive relationship with their intimate partner. A woman who can't or won't stand up for herself for her own personal reasons. And I believe it is my responsibility as a prosecutor and other prosecutors across the state to stand up for them and try to protect them. And this would jeopardize justice for those victims. It would jeopardize justice for our children who are victims. Even every day it grows. The number of reports, the stories in the news, and that you hear on a personal level of people trying to solicit young people on the internet for sexual encounters. It's just unbelievably amazing to me how prevalent it is. It would prohibit us from using similar transactions in virtually every case that commonly a child is the victim in. Child molestation, child pornography, and oftentimes domestic violence. And the last class of victims that it would jeopardize justice for are the elderly. The elderly are often victims in fraud schemes. We have people who travel from state to state. They rip off people for $200,000, $300,000 in Florida, take all the retirement that elderly folks have saved. They take it all. They wind up getting prosecuted. Maybe it's their first time. They plead out and they get probation because the prosecutor hopes that they can get some restitution paid for those victims. And the next thing they do, they move to Georgia and they do the same thing. And the jury in Georgia won't know about those cases in Florida. And they won't know that the folks in Florida lost their life savings before the defendant came up here and did it to them. So we have the potential there for not protecting our elderly as well, especially in those fraud cases. But it's not just the fraud cases. It's violence and neglect situations in convalescent homes, in nursing homes, in individualized care, where you have elderly people who oftentimes aren't conscious enough to even know what has happened to them. So they can't testify as to how they were injured or mistreated or neglected or abused. But that person who is the perpetrator has a pattern of doing this type of activity. And if we can put that into evidence, it helps ensure justice for those victims. So this bill will really damage our ability to secure justice for our victims of domestic violence, our children, and the elderly. Now, the uniform rules do provide a very clear procedure for the admission of similar transactions. And it is very clear in Georgia law that the ultimate decision to admit the evidence or to keep it out rests in the discretion of the judge once the hearing's been held and the findings of fact have been made. Under Georgia law currently, it can be used, similar transactions can be used for these purposes. These are the approved purposes. There is no toss it out there, just see if it sticks, see if it sounds good, see if it makes that person look bad or seem more like a criminal. It must be established in court that the evidence is offered for the purpose of showing intent or lack of mistake. When the domestic violence abuser says she fell down the steps, this is the 10th time she fell down the steps when he was standing at the top of the steps with a beer in his hand. Lack of mistake is an important aspect. It can be used to establish bent of mind, motive, intent as well. Those things are very important. And with all due respect to my good friend, intent is an element of every crime in Georgia. And the judge will instruct every jury that tries the case that intent must be established and proven by the prosecutor beyond a reasonable doubt. Now, it may be inferred by the acts of the defendant, their lack of action, any evidence that's adduced at trial, but that is part of our burden in every case. So we do have to prove intent. With limited exceptions for strict liability crimes out of Title 40, which are traffic offenses, but we have to prove that. And as prosecutors, all of us gladly bear that burden. We don't have a problem bearing the burden of seeking justice for this state. That's why we're here. We're certainly not here for the money or for the great hours or for the wonderful visits we pay to the legislature. We are here because we want to seek justice and stand up for what is right. And that is why we are here today. We want to stand up for the victims that we work hard to try to protect and seek justice for. Justice is not always a conviction. It simply isn't. And that is not our goal. Our goal is not, in being here today, is not to make our job easier. That is not the goal. The goal is to try to protect the rules the way they are now, to help us ensure justice for victims. So we appreciate this opportunity, and we encourage you to oppose this bill. And I'll be glad to answer any questions.
Questions for Solicitor Abernathy, Representative Abrams.
I preface this by saying that my knowledge of criminal law is pretty much law and order, so I have a couple of questions. I'm a tax lawyer. It's of no use to anyone but me. Several times you said that this law would prohibit the introduction of this evidence. Is it strictly prohibited, or is it prohibited using the similar transactions law?
It would strictly be prohibited the way the statute is drafted.
So in the case of the woman who was the victim of domestic violence, there would be no way for the prosecuting attorney to ask her about the number of times she was admitted to the hospital during the course of her marriage?
No. No. It would not be available as evidence against the defendant under this bill.
Okay.
Whether she would take the witness stand or not, we could not ask her those questions and bring in his prior acts of violence.
Well, without bringing his prior acts, you could not ask her about her activities. You could, at all.
My experience with that is that, practically speaking, she had a lot of accidents and she fell down the steps a lot. Now, there are cases when, after you ask a victim about that enough times, and there's enough situations that the jury completely disbelieves her, but that's a rare circumstance. And again, typically they claim the privilege, so they will not testify at all. So you don't get to cross-examine it.
And if I can follow up, I guess my concern is that I'm struck with weighing the probative value of having information versus the inconsistent application that leads to false conviction. And I know as a prosecutor, you certainly have an obligation. Not pulling you out of that role, but can you speak to how as a policymaker I can strike that balance between those who are wrongfully convicted because of the introduction of similar transactions, which, while to Chairman Knox's point, on first blush, you can certainly add all the jury rules you'd like at the end, but if a person believes, or if this person has been seen to do something before, it is human nature to assume it will happen again. How do I strike that balance between the concerns that you raise versus the very strict concerns that I have for people who are faced, particularly in the state of Georgia, faced with incarceration unduly and unfairly?
I understand. As to the probative issue, the judge must weigh that in each individual case based on each individual similar that is offered. So if you have a defendant and the state's filed a notice of similar transaction on 5 different incidents, on each incident the judge has to weigh the probative value versus the prejudicial value. And that's one thing that the judge may exclude that evidence on. As to it not being used uniformly across the state, this bill does not require it to be uniformly used across the state. This bill does not require us to use similar transactions. It is always in the discretion, and with this bill will still be in the discretion of the prosecutor to file that notice of similar transaction or not file it. And once it is filed, the prosecutor can withdraw that notice, and up until the moment they plan to put that witness on the stand during the jury trial, during the guilt-innocence phase, they can withdraw that and never put that witness up on the stand and not use that evidence. So it will not guarantee any kind of uniformity across the state. One of the things that severely limits your ability to use similar transactions is the availability of witnesses to the actual similar. You have to have the officer or the victim or someone else who can identify the defendant, say what they did, and put that evidence. It's almost like a mini trial as to that issue. Oftentimes, you can't locate the witnesses. So you may file the similar transaction notice because the criminal history shows that prior crime. But when you begin to try to get the report, find the witnesses, see if you can actually lay the foundation you have to lay, and then prove what you have to prove at trial, you can't do it. So that's why you see a discrepancy across the state. And Mr. Knox is right. In jurisdictions where the prosecutors carry 1,000 caseload per assistant DA, they probably file a lot less similar transactions because they're just trying to keep up with indictments, their motions, calendars, and get cases ready for trial. But in jurisdictions where they either have more administrative help that can do that, or where the assistant DA has more time or perhaps is more zealous, then they tend to file those notices more regularly. But that's where the discrepancy comes in. You're welcome.
Representative Collins.
Yes, thank you. A question, you brought up the issue of domestic violence, and one of the questions I would have, and I understand your concern about this and being able to show similar transaction, is it not true that also the Supreme Court has actually weighed in on this recently with the Crawford decision, which has made this even more difficult now, which Representative Knoxville, even intent there, Crawford on top of this would be very damaging in domestic violence cases.
That's correct. The Crawford case excludes a lot of evidence that you would have when the victim is unavailable because they assert the marital privilege. So you're very limited what can come in as to the crime that the person is accused of based upon that decision. So that really affects our ability to stand up for those who can't stand up for themselves.
Thank you, Mr. Chair.
Representative Levitas.
Thank you, Mr. Chairman. Yesterday, when we were considering another bill, we heard an expression, or at least I did, about not wanting to ruin the good in search of the perfect. And I guess my question is, judges make those calls every day as to what evidence belongs in and what doesn't. So even if you went through Superior Court Rule 31.3, even if you go through the factors that are listed in Williams, the judge can even at that point say, can he not or she not say, notwithstanding the fact that I think this is otherwise admissible, I see this as being too inflammatory. And we entrust the judges to make decisions in all kinds of cases every day in all kinds of situations on the applications of rules of court, law, the Constitution, and all these other things, right?
That's correct.
And there may be a case or two, might there not, where a bad a similar transaction that may not belong in does slip in, that may get overturned by the court on appeal. That's probably happened before, hasn't it?
Probably. I can't remember any case that is like that where one got in that was then ruled but there may be.
There may have been, but I guess my point is a policy decision as a prosecutor, and I know you're a solicitor, but I think you can speak to district attorneys who prosecute these cases too. How do you feel about weighing the balance in the public interest in terms of protecting victims and the citizens of Georgia for excluding entirely similar transactions? How would it affect you, the job that you do, and your fellow prosecutors in the DA's offices throughout the state, if we eliminate entirely this method of proving identity, motive, bent of mind in all the kind of cases you've talked about? I had one personally where the victim had rubbing alcohol poured on her by her boyfriend and lit on fire. She was not surprisingly a recanting victim. And the only way that we could prove that the defense of accident, which is what he claimed he was smoking a cigarette, that the rubbing alcohol was being used to give him a massage, and that he accidentally lit a cigarette and that caught her on fire. He also, when he attacked her with a machete a few years before that, claimed that it was not he that had attacked her, but rather she that had attacked him, yet she was the one that had the cuts all over her arms. So my question, if you had a case like that, and you couldn't use, you have a recanting victim, a reluctant victim, a hiding witness, if we took that away from you, how would that affect the balance of the public interest and the ability to protect citizens in your judgment as a prosecutor?
Well, the balance would be far askew, because when you're talking about domestic violence usually occurs in the privacy of a home. And when I'm saying domestic violence, I'm talking about adult domestic violence, but it can be perpetrated against a child. It can be teenagers and children. It just depends. But domestic violence occurs usually in the privacy of someone's home. Most of the time, the only witnesses are other residents of that home. Okay? So you've got your perpetrator, your victim, and other people in that home who have been conditioned to accept that as normal behavior in their home. So they're not going to be witnesses who stand up. A 6-year-old child, a 10-year-old child who has seen their father beat their mother every day of their life, or even once a week or once a month, it's not going to stand up and say, my dad hit my mom. They're going to say, my mom fell down the steps. And when you don't have that evidence of similar transaction like you used in the Smith case, you lose that case. She goes back home with him, that child grows up in that cycle of violence, and that child grows up to believe that that is normal life. So as a young man seeking a wife, he seeks one he can dominate, abuse, and push around. And as a young woman seeking a mate, she seeks somebody who's going to tell her what to do, when to do it, how to do it, and then call and make sure she's doing it like he told her to, and she's where she's supposed to be. So that's how we continue the cycle of violence from generation to generation. And that is why when you ask children like that, even if they're going to be candid, did your dad hit your mom last Friday? I don't know. Now, if you ask my children that, they'd know if somebody had hit me in our house, because that doesn't happen in my house. But in a home where you see violence every day, when you see violence routinely, that child can't differentiate last Friday from this past Friday, from next Friday. They're all the same to them. That's normal. They've been conditioned to accept that as normal. So even if they're willing to be candid with the court, willing to be candid with the prosecutor, the reliability of their testimony is greatly diminished, because that is the routine in their home. And then you have the issue of whether or not they're going to go back into that home, and how are they going to be retaliated against for standing up for their mother? Are they going to wind up in defects custody and having to go through the problems of that system? You know, what's going to go on there? So as a prosecutor, how will it affect us? It will greatly diminish our ability to stand up for victims of crime, most particularly those who can't or won't stand up for themselves.
Further questions? Thank you, Ms. Abernathy.
Thank you. Glad I could help.
Good to see you.
Mr. McDade, I don't know if you can match that. I wouldn't even try.
No, sir.
Please.
I'll swap you one spay hospital.
Oh, no, never mind.
Mr. Chairman, the witness left. Could I just ask, is there anything that you can do to salvage this, or it just needs to go down the tubes totally?
Think carefully before you answer that.
Oh, boy. Mr. McDade, why do you privilege the witness?
She works for Mr. Knox. This afternoon, so I want to be careful.
With all due respect to my really good friend, there's
I'm keeping a little tally up here on how many times you referred to him that way.
I had to say it a lot. No, in my viewpoint, and I believe that of my associations, which is more important than my personal viewpoint, I'm here really on their behalf, and their viewpoint is it cannot be salvaged.
Thank you, sir.
Mr. Moss, do you want to weigh in on this? You had signed up, or are you going to stand on the excellent? Kirsten Rambo.
Excuse me. Thank you so much, Mr. Chairman and members of the committee, for giving me this opportunity to speak before you today. My name is Kirsten Rambo, and I'm the director of the Georgia Commission on Family Violence. And I'm here today because, as Ms. Abernathy said quite eloquently, I think that this bill would actually have a devastating impact on the issue of family violence. I am certain that this is not at all the sponsor's intent. As Ms. Abernathy said, her good friend, I know, did not intend that, and I don't think the words family violence appear anywhere in this bill. But I am here to call attention to what I think is a major and serious unintended consequence of the bill. In order to do that, I just want to tell you a little bit about the scope of the problem of domestic violence here in Georgia. Last year we had 107 deaths due to family violence here in Georgia that we know about. Over the past 4 years, almost 500 people have lost their lives due to family violence here in the state of Georgia. A national study was recently released that tells us that Georgia ranks 7th in the country for its rate of men killing women, and the vast majority of those are intimate partner homicides. Obviously, that is not a ranking for any of us to feel good about, and those are just the deaths. Over 9,600 victims and their children were provided emergency shelter due to trying to escape violent homes last year alone. Another 3,000, more than 3,000, were unable to get that shelter. They wanted to but couldn't because of lack of space. So I tell you all this just to give you a sense of how big and how serious this problem is here in Georgia, because, like I said, I believe that this bill will have a tremendous impact on family violence here in Georgia. My office runs a project jointly with our state coalition against domestic violence to study homicides that result from family violence as a way of trying to prevent future deaths and to solve the problem of family violence. And that project has yielded some important data that I think is really relevant for our purposes here today. Most strikingly, in the domestic violence homicides that we've studied over the last 3 years, we found that 85% of perpetrators had a history of domestic violence against the victim. 85% of the perpetrators of those fatalities had a history of domestic violence against the victim. And that finding just supports what experts in the field already know about domestic violence, which is that it's a pattern of abusive and controlling behavior. It is almost never an isolated, one-time incident, and it's generally escalating in nature, as Ms. Abernathy alluded to. What starts with a shove or some just real ugly or humiliating name-calling often leads to beating, burning, sexual assault, strangulation, and sometimes fatality. So it's virtually impossible to understand domestic violence without understanding this really basic fact about it, that it's a pattern and that it usually escalates. I think this bill ignores that psychology and the reality of domestic violence. Most domestic violence prosecutions happen at the misdemeanor level, and I think by disallowing these similar transactions, it'll make those prosecutions nearly impossible. I think if the state can't present the true and complete picture of what's going on in this relationship, this perpetrator's clear pattern of escalating behavior, I think it'll seriously obscure the truth of the situation. Judges and juries will be asked to make decisions based on incomplete information. The place that I work, the State Commission on Family Violence, has been charged by this legislature with ending family violence in the state of Georgia, which is a tall order, but we're working on it. Our only hope of combating family violence, though, is to show abusers as early as possible, as soon as they're involved with the system, which is generally at the misdemeanor level, that society is not going to tolerate this violence. And when they don't get that message, I'm here to tell you they are emboldened because they know they can get away with it. They know they're not going to be held accountable, and they often escalate, sometimes with fatal results. And I think this bill, or any bill that takes away prosecutors' ability to hold them accountable and to send that message, will only encourage that kind of escalation. So I would ask the committee to consider that as it considers this bill. Thank you.
Questions of Ms. Rambo from the committee? Thank you very much.
Thank you, Mr. Chairman.
I think that was all that we had that had signed up to speak on that bill. I'm sorry, Rick Malone. You're going to waive his...
Your Honor, we're waiving his testimony.
Okay, thank you. Thought so. Chairman Knox, you want the final word?
Yes, sir. Very skillfully, as my solicitor has done, turn this into a family violence bill. And I assure you this is not a family violence bill. It's not an anti-family violence bill. If the only way that you can get a conviction in a trial is to use similar transactions, you have a really sweet case, and you probably shouldn't have brought that case. If you're a DA or a solicitor who doesn't have good enough evidence to try and win the case on the basis of the case that's before you rather than on other extrinsic matters. It's a terrible thing, family violence in Georgia and elsewhere, and I submit to you that it needs to be solved. But I think it has something in common with it's a disease, I think, by now. It could easily be a disease, and I think it's a disease that's very similar to alcoholism and drug abuse. And I don't think it's going to be cured by the criminal justice system any more than alcoholism or drug abuse is being solved by the criminal justice system. I'll submit to you that probably treatment and more treatment resources for persons who are afflicted by the disease of family violence would be a better solution than trying to make cases against individuals accused by using any kind of evidence that's available. Ms. Abernathy spoke about the invocation of the spousal immunity, and there's a good reason for that. I think it's one of the things that the legislature can take credit for, and that is that we've said that in a marital situation, we're not going to go and submit and substitute the government's judgment for the judgment of the parties. We're not going to force victims to testify if they don't want to. As bad as we may think that is, as dumb as we may think that is, that's not our decision to make. That's their decision to make. We can assist them, but we shouldn't turn this into a social work program. It's a criminal trial about a criminal act that's before that jury or before that judge, and we ought to leave it there. And I'll submit to you that, that as we sit here today, I think the legislature has provided ample means for the prosecution to win cases. We've recently given equal strikes. We're asking for a less than unanimous jury for for the death penalty. We've done a number of things in order to make it easier for the government to find someone, to prove someone guilty. This is not a case of, this bill is not about family violence or domestic violence, either one. It's long held in our law that a spouse cannot be required to testify against their spouse. And this law doesn't change that. And I'll submit to you once again, if you don't have good enough evidence in this case to win it, you probably shouldn't have brought it. And you should be able to make a case, and you should be able to win a case based on the evidence in the case, not upon some extrinsic evidence. If you listen very carefully, I think what you heard here today is that if we don't have similar transactions, we can't win any cases. We've got to have similar transactions to win cases. I'm going to say to you that I know for a fact that my good friend, the Solicitor General of Forsyth County, can win a boatload of cases without similar transactions.
Hear, hear.
Now then, let's get back to the issue that is before us. I think the solicitor makes I think the solicitor makes a good argument for perhaps increasing the penalties in some cases. If you think that it should be a felony to commit family violence, maybe we should pass that law, that it should be a violent felony to commit family violence. But I'll submit to you that if you did, you'd get a whole lot less convictions for family violence. People would be even more reluctant to come and bring those charges before the court. I think there's plenty of cases being made for family violence now. I think we've come a long way on the issue of family violence. I think we're doing better as far as the judicial system, and we're doing better as far as the resources that this legislature has provided. I think we're entirely justified in relying on those resources that we've brought to bear. I'm once again going to say to you that this is an issue about what the government should have to prove and what the Constitution does. The Constitution says when you accuse somebody of a crime, you ought to be able to prove that crime beyond a reasonable doubt. The reason for that is to preserve the innocent, not to convict the guilty. Thank you, Mr. Chairman. I'd ask for a due pass.
Final opportunity for questions to the author, comments from the committee. Representative Setzler. Excuse me.
Could I be recognized to ask a question to Mr. McDade?
Sure.
Or would you, if I could, Mr. McDade, the author of the bill raised the question that 2 years ago this General Assembly provided for equal strikes between prosecution and defense. Last year brought HB 1059, which very significantly impacted some of these violent cases and some cases that were less than aggravated with respect to cases against children. Yesterday, this committee passed out 11-1 sentencing verdict for the sentencing phase with respect to death penalty cases. What would be the harm of passing HB 26? I mean, is this not just a reasonable balancing measure? I asked the question to you just to get your response.
The harm would be, as Solicitor Abernathy said, you would be excluding from the protections that the courts and the state have given for over 150 years to the other class of victims that his bill excludes from these protections. It would be a great dishonor and disservice to domestic violence victims, to children, to the elderly. This bill would narrow tremendously the protections to that finite class he's defined in that bill.
Would you consider the other actions of this legislature relevant to this discussion?
I do not. I don't believe that the legislatures, I don't believe it's the public policy statement that you balance what you do in one instance against what you might do in another instance unless the issues are the same issue. And I don't believe the issues are the same in what this proponent offers in this bill. This bill narrows protections. This bill removes protections. This bill exposes victims to further harm. And if you had another bill where the bill exposed other victims to further harm, you could compare the two. I don't think the other bills you passed expose victims to further harm.
So you don't think that other actions of the legislature would be similar transactions, as it were, that should be brought into this discussion? Let
me answer that in all candor. If it met the test of exposing other victims to further harm, and you could make out that case, and I would agree that they should be, but you can't. At least it would be my position, and I would take the position that they wouldn't.
No further questions, Mr. Chairman.
Further questions? Further questions or discussion? It's a pleasure of the committee.
I'll make a do pass.
I'm sorry.
Make a do pass.
We have a motion or a move by Vice Chairman Mumford. We have a second by Representative Abrams that we give House Bill 26 a do pass recommendation. Discussion. Representative Abrams.
I'd like to say to Ms. Abernathy and to the family violence advocates, I believe absolutely that there is, I'm compelled by your concern and by the very legitimate task that you seek to undertake. My concern, as I stated earlier, is one of weighing the balance of public policy, and I am, I think, in line with Chairman Knox, in that I believe it is imperative that we not only protect the victims, but that we protect the justice system. And I find inconsistency of application to be a very prevalent issue in our criminal justice system, and because of that, I support this bill.
Secretary Beard.
Just real briefly, as much respect I have for Representative Knox, it is time that we start putting the victims' voices first. Too many times the victims are left unheard. They get hurt, they get killed, and there's a lot of pieces to pick up afterwards. If this bill passes, we're going to allow more of that to happen in our state. And I would ask that you vote against this bill and kill it now before it has a chance to get to the floor and victims are hurt. So I ask for your support on killing this bill. Thank you, Mr. Chairman.
Representative Levitas.
Mr. Chairman, I too have nothing but the utmost respect for Chairman Knox, and I appreciate the sincerity and passion that I believe he brings with him when introducing this bill. And I had not planned on saying anything other than raising my hand in opposition to this bill, but Representative Abrams, whose opinion I likewise respect greatly, has made me think that it at least needs to be said. I know that I am not the only former prosecutor on this committee, that that Vice Chairman Mumford is as well. But I will tell you from being in the trenches, and I will tell you from prosecuting not just domestic violence cases, but this is true of child molestation cases, rape cases. If you want to put aside the DUI cases, you obviously know I have a passion for that as well. We're talking about, you want to talk about a fundamental change in the system. It to me borders on a very dangerous argument to characterize similar transactions as not evidence. When a prosecutor brings a case, and that includes similar transaction evidence, that is evidence. There is a charging before we even get to the point of whether or not there is evidence that's going to be admitted. There is a hearing. The hearing, the prosecutor has to establish three things. If those three things are not established, the evidence is excluded. Even if those three things are established, the judge, in his or her sole discretion, can say, I don't believe that these things belong in the case. Any law, any rule of evidence, anything that goes on in a court is susceptible to application that's going to lack absolute uniformity. Quite frankly, I think judges are there to look at cases individually and not try and apply uniformity to every case, because each situation, each defendant, each victim, each witness demands that the court look at the law and apply the facts and the law to the case. But to exclude an entire range of evidence in the most crucial cases, and again, this is not about domestic violence, it's about rape, it's about incest, it's about any crime that you can think of where motive, intent, bent of mind, and course of conduct are important. If we exclude this, what we are doing is we are saying we're turning a deaf ear to crimes, and it's not just about the victim, to fairness and justice and the administration of justice, because we don't trust that in each and every case it's going to be applied uniformly and across the board. I would submit to you that this type of evidence that has more scrutiny applied to it than any other kind of evidence introduced in any case. And I commend the chairman for bringing this bill, but I stand in strong opposition to it and would ask that the committee vote this down.
Further discussion on the motion, Representative Setzler.
Thank you, Mr. Chairman. I too appreciate Chairman Knox's willingness to bring the bill, and I appreciate the discussion on this and the thoughtfulness that's been involved on both sides. I asked my question earlier to District Attorney McDade, almost as a tongue-in-cheek reference to the actions of this legislature over the last 3 years. I think we've done some good things, but I think it's well worth mentioning that the overall balance of justice versus the accused and the victim needs to be maintained such that justice is upheld in the state, recognizing that's a delicate balance. I think our action on equal strikes was a good action. I think our action last year in our action against sex offenders was by and large a very good action. I would just caution the district attorneys and solicitors, as I would caution the committee and as I would caution anyone in the broader law enforcement community, we need to maintain a very careful balance as a state. Raising mandatory minimum sentences, making convictions easier through civil, or rather through criminal procedure, year after year after year after year will interrupt that balance in a way that's dangerous, in a way that would concern me about overall justice being served. It's with that concern that I plan to vote against this bill, because I think it unduly breaks that balance. But I think it's a point that needs to be deeply considered, and I would ask the committee to move forward very cautiously in considering these kinds of measures in the future.
Vice Chairman Mumford.
I'd like to speak to this bill just briefly. I believe this bill's probably fixing to be defeated, and I'm not sure that this is the perfect bill that needs to be brought, but I certainly intend to, after the vote on this bill, I and other members of this committee are going to meet with Chairman Knox, and we are going to see if we can perfect a bill which might improve the situation relative to similar transactions. I have a real problem about crimes that have specific intent, crimes that have in general intent, and they all seem to be lumped together, and the courts have not done a very good job, in my opinion, of policing the admission of similar transactions. I think that there's definitely a problem that they oftentimes cast too broad a net, and I frankly must admit that it troubles me when I hear a solicitor, no doubt a good one, who is talking about impeaching her own victim in order to gain a conviction with similar transactions, which is what I understood her to say that she was having to establish when the victim didn't want her assistance. With having said that, I just wanted to state that before we do take a vote in this matter.
Thank you, Vice Chairman. Representative Mangan. Thank you, Representative Mangan. Next.
I'm really one of the ones that hate to be very vocal in this committee, and I really regret that I'm on this committee, to be very candid with you. I'm not kidding either.
Don't take a vote.
And so,
Most sought after committee in the House is what the chairman said.
Yeah.
I know, but right now I see a very dangerous thing happening in America for democracy. And I think that my grandmother was murdered. I have people that I know that have suffered. But I know people that have suffered on both sides, and I think that when I hear some of the members of this committee make this statement to protect the victims, I do understand that. And I guess I'm concerned that we are creating an atmosphere where judges are going to be attacked similar to the ad that we saw yesterday that came in here. And we are all over the map fighting, but we're not really trying to get to justice. We're trying to prove we are tough as hell on criminals. And some of us know, even if we close our eyes to it, that that's how some people get elected in here. And if you call, I saw a bumper coming in here that says, what it says, soft judges, it's soft. Oh, we're all over the. What does it say?
Soft judges make hardened criminals.
Right, that's it. So I just so I guess, guys, what I'm trying to say is, I was asked what was my position. I didn't really have a position on this bill. I'll be honest, I do have some concerns for it, and it may need to be studied a little more, as Chairman Mumford was just stating. But I think we are going overboard with an atmosphere that is not allowing us to get to, as my distinguished solicitors came up here to talk about, justice. I don't want it to just be just us. There are some communities that say that. If you're not aware of it, when 82% of that list over there, 173 people were exonerated from death row. 82% of them were African Americans. They're not 82% of this damn country. So something is wrong with justice in here. Whether OJ is guilty, something is wrong when you can buy your way. I hate to use that as an example, but if you have money in America, you're buying your way out of justice. And I'm standing here as one who, those people that don't have money that come in court, that don't even have a lawyer, I don't want them railroaded. So if you want to know where I stand in here, I stand for the little guy who doesn't have anything. That's why I'm in here, and that's why I speak up. And with all deference to my colleagues in here, I want you to put every criminal in jail. I mean, in fact, I told someone, and you all may not believe, I said to a colleague, we need to maybe bring something, and this is bad, I won't put it on the record. We need to make jail uncomfortable. I don't think jail should be, you go and have, I don't think it should be comfortable. I'll leave it like that. But I do not want to see another person to come in and say, I spent 22 years in jail because I looked like Randall Mangum. And there was a guy, I'm serious. I had someone call my law office because I said, what are you talking about? Well, this guy's name is Randall Mangum. I said, wait a minute, I have never heard of another Randall Mangum in my life. And they were hunting me down. Where was I on such and such a day? And you guys think I'm kidding, but I am serious as a heart attack. And I'm telling you, there are opportunities where we need to get to the victims to have justice, and justice sometimes is to castrate them. If you want to do that, some people do. But I'm just trying to say, get the right castrator, because once you take it, it's gone. And I don't want you to come back and say, oops, we made a mistake. So from that angle, guys, I don't really care.
I'm glad you turned right and not left.
No, I'm ranting a little bit. I'm venting because we are getting a dangerous atmosphere. I was in Alabama when they did their judicial elections. It was a farce. And if we're trying to catch up to Alabama, God, dog, really? If we are trying to be like Alabama, I'm a son of Georgia. And guys, we got better things to deal with. Let's do something that really helps victims, if that's our goal. But I'm for justice, not just putting somebody in jail to say I put them in jail. Thank you. And, I think this bill you know, it doesn't look very good. But I do think that we do need to examine what we're doing. Thank you very much.
Where were you?
On that day.
Have an alibi?
Trust me, if I ask you where you were on March the 13th of 2006,
Or yesterday? I couldn't.
I'm serious. And then I gotta go spend money to go and say what the. I mean, really, it gets ridiculous. And
Did you have to ask that, Mr. Chairman?
serious. I'm just telling you, it's not a good thing.
I'm just glad you looked right. Everything castration came up.
Representative Lunsford.
Oh, gosh.
Thank you, Mr. Chairman. I think that Representative Mangum's problem is probably quite obvious, but if he'd change his name to Billy Bob or Bubba, there would be much fewer people he'd be confused with. Mr. Chairman, with all due respect to Chairman Knox, who I think as highly as anyone in this House of Representatives I've served with for years, and we came in together. This is an extremely complex and complicated issue, and we've heard testimony passionate on both sides of the issue. I would like to make a recommendation, Mr. Chairman, that we table this issue, but don't kill it, to force the sides to get together with Representative Mumford, Representative Knox, or someone during the interim, so that we can analyze it in further detail, and possibly they could come up with something they could work with together for next year. And my motion would then be to table with your approval, and that's only if we could work with Representative Knox, because he's one of my dearest friends.
You've heard the move. We now have a motion. And I take that as a substitute motion.
Yes, sir.
Motion tables
Well, let me comment or two. I'm not sure the author of the bill, for whom I have much affection and respect, and who I think probably has more courage than any other member of this body. I'm not sure he agrees to a table. Although I would like for this dialogue on this bill to move forward. Having said that, I don't think that the dialogue should be limited to Forsyth County. I don't see a lot of I don't think he and Solicitor Abernathy will be able to resolve this on their own. I think they will take others to be involved in that process.
I've offered to trade Spahos and Floyd, Mr. Chairman.
Floyd?
I throw in Floyd as well.
Mr. Chairman, I will accede to the wishes of the committee. If it's their desire to table the motion, I think it would be remiss of me not to honor their hard work and consideration in the bill.
I sense it is their desire to continue the discussion, but probably not this session, and so that a motion to table would be a better way to do that than to take an up or down vote on the bill. And so, sensing that, I'm going to call for the vote. All in favor of the motion to table, please indicate by raising your right hand. All opposed?
Think back.
5-4 against table.
Mr. Chairman, parliamentary.
Representative Setson.
I'd just like to ask the author. I know he's politely deferring to the will of the committee. I don't think this bill needs to pass this year. I mean, as a matter of public policy, I don't know if leaving this bill alive for further consideration is the way to do it, or if giving an up-down vote and then recreating a new bill that does something, takes in a different direction. I mean, does the... and I'm not sure I understand the votes against motion to table and what that means. Could I...
That should be pretty clear, I think.
I think you need to look at who voted against the motion.
I mean, does... I guess my question is directed to the author. Would you prefer an up-down vote, or would you prefer it be tabled?
Diane, what was the vote? 2. All right. 5-4 against table.
In favor.
For table. Okay. Then it's on the table.
Mr. Chairman, that leaves me 22 minutes to present my bill and get it passed by committee.
We hate that.
That is perfect. I'll probably have 3 or 4 minutes left over, I would imagine.
We're going to stand down for about 1 minute. Come here, Representative Lopez.
While y'all stand down, I'll get dressed.
Let's have order for just a moment. I want to know a little bit about scheduling.
Stops.
We have one House bill left on the committee's calendar after working all day yesterday and all day today now, except for a couple hours early this afternoon for other meetings. It is now 10 after 5. And I committed to this committee early this session that we weren't going to have any all-nighters here this year. We don't need to. So, but this is an important bill coming up, and I want the committee to be fresh and have the ability to devote some focus to it. And so what we're going to do is this. We're going to adjourn here momentarily. We're going to meet upon adjournment Monday. This committee will not meet tomorrow. It will not meet Friday. But we will meet upon adjournment Monday, and we will consider at that time only House Bill 336 by Representative Levitas. Do you wish to be heard?
Not until the chairman is completely concluded with his business. I think 6 or 7 hours will absolutely cover me, and unless I have witnesses that want to testify also.
Well, I think you saw an example this afternoon of having one voice speak articulately and concisely and cover the points, and it's, and I know Chairman Knox, so it depends on which side they speak on, too. I think a good presentation like that would be of great benefit. But that's what we're going to do, and that will then probably, well, that's realistically the last opportunity you would have then to take a due pass with that bill if you get it to the Rules Committee. And that will be the final House bill that we take up before day 30. Because day 30 is almost upon us. I'm expecting that we will, other than that bill, we will not meet in full committee next week after Monday. And though I would encourage, we may meet later in the week, I'm not sure, I would encourage the subcommittees to meet and move on take up some of the Senate bills. Any questions about scheduling?
Just whenever you're concluded with your business, I do have one.
I recognize you.
Mr. Chairman, it's my understanding that there is a special event occurring today, not just the fact that we will be addressing House Bill 336 on Monday, but it's come to the attention of the committee and witnesses that, in fact, there's a special day, and they've requested that we have John Lunsford lead us in a special recognition song in that event. So I'm going to turn the microphone over to Distinguished Hawk.
You're going to sing?
No, sir, I'm going to turn it off, but if y'all want to sing, you can. I'm just going to wish you well, Mr. Chairman. How's that?
Thank you very much. Thank you very much.
Happy birthday to you. Happy birthday, Mr. Chairman. Happy birthday to you.
Oh, and thank you for my card. I don't know what I would do. I never get to spend my birthday with my family, but I get to spend it with my committee, which is even better sometimes. But so thank you all very much.
We'll have a lighter because Mr. Bearden had it loaded under the front seat.
He carries a blowtorch. Do we have plates?
Yes, we do.
Let's cut it in here. Meeting's adjourned. On to the cake.